to the camera, we're going to start. They're supposed to give them 30 seconds. This special meeting of the Troy City Council is called to order. Can we have the roll call, please, Mrs. Bartholomew?
Mayor Schilling?
Here.
Councilman Beltramini?
Here.
Broomfield?
Here.
Eisenbacher? Fleming?
Here.
Paulette? Kerwin? Here.
Quorum present. This evening, we are here to have a discussion on the city manager contract, and we have with us, of course, John Zerleit, our city manager, and we have with us Craig Lang, our attorney. So who's going first? John and then you, okay?
If you don't mind, I'll go first.
Go ahead.
First of all, I want to thank you for your confidence in me by your appointment. I'm not going to make any promises because one person can't meet all the challenges that are coming up. But I think that working in a partnership, we can successfully meet these most difficult times facing the city. We do have the issue of an employment agreement. It's not really my employment agreement, it's our employment agreement because the terms and conditions there too have to be agreed to by both parties. And although this is a public meeting, I thought that perhaps you could have a freer exchange with Mr. Lang, your attorney, if I were to leave the room. And I'll be happy to do that. As Craig is addressing you, and I'll go back to my office. If you have any questions of me, I'll be about 25 seconds away.
Okay.
Thank you.
Thank you.
All right, thank you.
Thank you.
We appreciate it. Okay.
You can get your shortcut.
Do you
Oh,
mind?
he's got a shirt.
Yes, thank you, Mayor.
Only if he has the key.
Okay, ratify the contract, please.
Why don't you sign the contract?
Get a key.
It's even better than a key to the executive order, isn't it?
I want to lock it, Craig, so we don't have the same issue.
All right. Well, I want to thank council for entrusting me with the opportunity to attempt to negotiate an agreement with Mr. Zerlag. It is exceedingly a difficult assignment when you know that it was a 6-1 vote in favor of bringing John back into employment with this fine community, and that job is of negotiating an agreement when you have two parties, the employer and the employee, both of whom are desirous of entering into a working agreement and attempting to find an appropriate contract that meets everyone's need is indeed a challenge. I have provided to you a draft agreement, and I have copies. Does anyone need a copy at this time of that contract? It was an amended agreement after some additional negotiations. Everyone has a copy. Let me speak to it then briefly before I open it up for questions from you and can assist you in any other way that I may. I have had an opportunity in the last several days to communicate individually with each of you. You each have expressed great hope that John Zerlag would reassume the reins of city management here for our community. At the same time, each of you candidly expressed your concern with the difficult financial times that both the citizens of the city of Troy, the residents, and the city itself is experiencing and will continue to experience. I know with my work on behalf of other municipalities that as housing values decline, our revenues likewise are being affected, and these times call for an experienced city manager to help guide the city as we go through this experience. John has over 20 years of experience with the city, and of course even more years than that in city government. I believe that the contract that I am submitting to you this evening recognizes the fiscal circumstances we face, despite John's lengthy municipal experience both with this community and outside of it, this contract will call for John to receive less in salary than was received by his predecessor, Mr. Nelson. I think that is a significant statement by John in terms of his willingness to work with our community. I have surveyed several comparable communities and have found the following city manager salaries: $159,600, $155,500, $144,500, and $137,900. That averages about $149,375. John's salary under this contract is proposed to be $140,000. In addition, this contract will preclude John from accruing future pension credits in either the city's defined benefit plan or the city's defined contribution plan. This plan, provision of the contract alone reduces John's compensation by an additional 10% of his salary. Based on a salary of $140,000, that is a reduction of $14,000. All other exempt employees, indeed I think all other full-time employees, accrue a pension while employed here, either through a defined benefit plan or a defined contribution plan. John will not, while serving in this position, accrue pension under this contract. Now, for purposes of internal comparison, because I think you have to not only look externally, but you need to look internally, I think it's important that you know that the two assistant city managers receive salaries of $135,000 and $128,300. Both participate in the city's defined contribution plan. For one, the city contributes 12% of his salary into that plan. For the other, 11%. That's, in terms of dollars, $16,200 for one and $14,110 for the other. Add that to their salaries and compare it to John's compensation. And if you care to measure reasonableness by the relationship of the city manager's salary to his assistants, this measures the test and meets the test of reasonableness. In short, I believe John's willingness to moderate his original contract positions and receive lesser salary and to refrain from participating in accruing future pension benefits speaks to his commitment to the city of Troy. I know there are some that are troubled by the fact that John currently receives a pension from the city of Troy. John earned that pension for his service to the city prior to his voluntary termination of employment in March 2006. He will continue to receive that pension under this contract even though he is reemployed. The amount that he receives will be unaffected by his future employment. This is not uncommon in my experience in either the public or the private sector. Many employees from GM on down retire from their employment and return to their employers and work on a contract basis. In the public sector, a wide variety of employees retire and return to work, often for different public employers, but they are compensated without regard to the fact that whether they're receiving a pension or not. Certainly, if the city had hired a city manager from another jurisdiction, from a Farmington Hills or from a Royal Oak or from some other community who was receiving a pension, his compensation for working for the city of Troy would be set without regard to that pension. No less, in my opinion, should be expected here. John earned his pension in Troy, and as such, we are getting not only an experienced city manager, but an experienced city manager with a long record of service for this community who knows the employees, knows the citizens, and knows this community. This is clearly, in my opinion, a win-win situation for the city and for John. In short, based on the salary figure of $140,000, which is, again, I would repeat, less than your previous city manager was making, as well as his willingness to relinquish any entitlement to pension for future years of service. In light of the comparables, both external and internal, I think this is a reasonable contract. And even in consideration of our fiscal times. And as such, I do recommend this contract for your approval. Thank you.
Council members, do you have questions of Mr. Lang at this time? Councilman Fleming?
Maybe I wasn't listening clearly enough, but I read here that the executives shall not participate in hospitalization, prescription, drug insurance coverage?
Yes, again, yes, that is, currently, John receives a medical care through retirement. He will not receive medical insurance under this contract through the general fund. That is additional savings, I might have mentioned, of $16,000, Mr. Fleming. That will not come out of our general fund, which, had we hired another city manager, we would have had to pay. Thank you.
Any other questions on that? I'm glad you mentioned that one, Wade, because that was the one I was going to, as I was listening to what you were saying in regard to changes between the first proposed contract and this one. That was also part of the first proposal too. And any others?
Madam Mayor,
Yes, Councilwoman Beltrame?
I don't have a concern at this point with any of this. However, I do notice an inconsistency between our resolution and the way the contract is drafted, which may be a problem.
Okay, let's
The
look at.
contract is drafted between the city and John Zerlag, and the resolution is to appoint a John Zerlag as city manager. And they are one and the same person, but probably one or the other should be changed so that they're consistent.
Mrs. Lowe, what would you?
The signature line does have his appropriate legal name, which he goes by A. John Zerlag. However, a very quick A. John Zerlag could be added on the first paragraph, and I think that would be appropriate.
And I didn't have it when I was talking to you on the phone, I'm sorry.
Is there any other part of the contract where we need to add that? Yes, Councilman Fleming?
Mr. Craig, could you also elaborate on Section 3, other employment,
Yes.
as it relates to consulting?
Yes, there has been, in addition, the word consult, that the executive may from time to time, historically, the language in this contract has said, may from time to time teach, lecture, or make presentations that will not conflict or interfere with his work for the city. The word consult has been added to that, Mr. Fleming. Mr. Zerlag desires to potentially pursue some consulting arrangements. If he does so, however, the agreement requires that he provide at least 30 days' notice prior to entering into any consulting agreement to each of you, so that you can review what this proposed consulting arrangement is and and inquire from him to ensure that it does not in any way conflict or interfere with his work for the city. So it provides you with a safeguard. I would note that currently in the city of Troy, employees are permitted to provide a outside work activity request to their department heads or city managers, and I've been made aware of at least 2 city employees at the department head level that have been approved for consulting arrangements, and this more or less does the same thing, but make sure that John has to keep you notified if that's going to happen, so that you can review and make sure you're comfortable with the arrangement.
Yes,
Just to
Wade?
follow up there, Mr. Langen, this will be my last question, the others can speak. In regards to that consulting agreement, in the event that he gave the council 30 days' notice, we looked at that and did not agree with that. We thought there was a conflict. For whatever reason, that the majority of the council felt there was a conflict. What would his responsibility be? Would we need to vote on that to tell him no? What would be the recourse? I mean, just play it out for me.
Wonderful question. I have discussed that with John at length, and he has indicated that if council was of the opinion that it was a conflict, it would be highly unlikely he would take it unless financially it made more sense to say, you know what, based on the money I'm going to get from this consulting agreement, if you don't want me to do it, fine, but under these circumstances, it's too lucrative to turn down, and I'm going to leave. I mean, potentially that could happen. But in essence, John has indicated he is going to honor your review of this. And I don't think that's going to happen. But John, we had candid conversation about this, and I think practically this language being in here, if council feels strongly about it, John will be attuned to your wishes.
Any others have questions, council members? Councilman Kerwin, were you saying one? I couldn't
Just
tell.
waiting to see if someone else
All right.
does.
Thank you. I guess my impression too from conversations with Mr. Zerlake that he in no way wants the consulting to interfere or do anything that would not be a good thing for the city of Troy. His first and primary focus is full-time as city manager, and as we know, that can be many, many hours and sometimes strange hours too when called upon for decisions. But I have every confidence knowing John's history here in the city of Troy, both as assistant city manager and as city manager, that will be so, that he will, put his duties as city manager absolutely, at the top. He cares very much about this community, just as we all do, and wants things to go well. He really does.
And the contract calls for that, I would add. I
Right.
don't disagree with you at all, Mayor. It does indicate that he shall devote his primary attention to this community, and the city shall be entitled to the full-time benefits arising from the incident of full-time work, services, and advice of the executive. So the contract absolutely calls for that result.
Wayne? Yes.
I mean, if no one else has a question, under section 14, termination, paragraph 1, it says, in the event the executive terminates this agreement, he shall give no less than 30 days prior written notice to the city clerk. Is that normal 30 days? If we look at the other contract for Mr. Ness, was it? I didn't compare.
was,
It's 30
yes.
days is normal. It seems like,
That's been
doesn't seem
standard.
like a lot to me, but that's normal. Okay.
Yeah, that's been standard all along.
Yes, it
Yeah.
has.
Anybody else? Christina, David, Jared? David, you do? Yes. Councilman Eisenbacher?
Again, tying in your previous statement regarding section about his priority of the city, I believe it was section 3.
Three.
Section
Section
okay.
3.
So in section 3, a violation in the opinion of council of section 3 doesn't appear to have a cross-reference to the termination section in section 14. Is there a link between basically any violations in this contract and termination, or is it something that we'd have a finding of the subsection 2 of the section 14 termination?
if I understand the question is, if we said, no, we do not want you doing that consulting work, and he said, well, I'm going to do it anyway, would that be a violation of the cause provision under this agreement? I don't think directly it would be. I would look at, however, 2D, small I, a pattern of neglect or persistent failure to perform the duties herein contained with respect to duties previously commuted to executive in writing by the city council, but only after the executive has been provided notice by the city council of its dissatisfaction with the performance of said duties, and executive has been provided a reasonable opportunity to correct his performance. You may be able to drive that question into that section, but in terms of a specific provision that talks directly related, I think was your question, paragraph 3, there is none.
Okay. I was just thinking in terms of enforcement process.
Councilman Brumfield?
If I understand everything that was shared, Mr. Lang, I'm looking at a salary of 140. And if we back out the 10% defined contribution or defined benefit plan that he would not be receiving, which is, it takes it down to 126, because that's real money.
Well, I would look at it the other way. It would be 140, and the 10% would be added on to the 140,000. So it would be 140 plus 14, 154,000 was if you had to pay him.
Right, I understand.
Compensation. So it's basically is not receiving that additional 14,000. So it's 140,000 salary period without that additional 10%.
And then the medical benefits, you said was about $16,000 savings?
That's correct.
Okay. And you know, I guess it's either way you want to look at it. I'm looking at it as if a person was hired in at 140 and they received the 10% defined benefit and they received the medical benefits. If you took that and you subtracted that, because he's not getting it from the 140, it's as if we hired somebody at 120, or I'm sorry, at 110.
I see what you're saying.
You know, I'm
You're
just
working
reversing
backwards.
it. Yeah. If somebody was hired at 110 and they received the defined benefit and they received the medical benefit, then they would, in essence, be making 140.
They'd be making 137, exactly. If they hired at 110, 11,000 would be the 10%, and 16,000 for family medical coverage, you'd be at 137, which would have been $3,000 of Mr. Zerling's salary.
And so I'm basically just backing it down to look at the
Right.
savings. And then in comparing that with our two assistant managers, Mr. Zerlag would be making considerably less than they would be making.
They received salaries of 135, I believe, and 128, plus 12 and 11% respectively.
Plus the medical benefits.
Plus the medical benefits, that's correct.
Councilman Eisbacher?
On my previous points, you had expounded on section 14.2 D1. What about on the next page at the top, 14.2 D2? That seems to be much more appropriate to the point.
That would be, you could utilize that willful misconduct, and that's a, willful misconduct is obviously a little ambiguous term, but you may be able to come under that provision as well. Yes. I'm not saying with certainty, because that is an ambiguous term, whether it's willful misconduct. These provisions were added to city manager contracts here about maybe 4 years ago. We didn't used to have this kind of good language in here, and we added these things to provide us some opportunity if in fact we had a circumstance where someone was basically terminated for what I would characterize as cause. So cause is a broad term, and I think there is some ambiguity built into this language, yes.
It concerns me that we'd enter into a contract where our labor attorney is saying that it's little bit ambiguous.
Well,
What
you
could we
shouldn't,
do?
because it is common in
Okay.
labor contracts for us, the term just cause, which I traditionally see in labor contracts for sake of discussion, highly ambiguous term. What is just cause? I mean, that's always, it's a term of art that requires consideration of a lot of circumstances and the ability to prove that someone did something and that the discipline imposed is consistent with the nature of the offense. That is such an ambiguous cause, but it's ambiguity within the context of a term of, it's a term of art, and willful misconduct, certainly, I've argued that many times in the past, and successfully, I may add. Just the terms themselves, first you have to prove it's willful, secondly you have to prove it's misconduct. And so that's the only reason I say it's ambiguous. Ambiguity is not standing alone a pejorative term, in labor at least.
Councilman Kerwin?
And Mr. Lang, would you agree that should the events that we're talking about happen, that the evaluation would be a good time to incorporate some of those specifics, which then later on would weigh in terms of this?
That's an excellent point, and notice is such an important thing. That's why small I, a pattern of neglect, persistent failure, goes right to the heart of what you're saying. It's just right on the money there, that we want to provide opportunities for employees as a general proposition to correct their behavior, and that's what this language offers in so many evaluation.
In the same section, 4, I have concerns about this and additions to the contract, Mr. Lang, because this contract sets a precedent. And often, we have seen where managers will take a look at that contract, and then that's upon which they'll base some of their things. So I'm wondering how this came to be.
You're talking about the expansion, the payouts if Mr. Zerlag is terminated without cause. That's
Correct.
Includes section 4?
This is, actually, the section is the same that we've been dealing with.
I mean,
14,
point 4?
and it's number 4.
Number 4.
And it's new language.
Well, partially, yes. Historically, we have had a provision in the contract that provides for 6 months severance in case someone is terminated without cause. This expands that. It takes us back there to 6 months, but it opens up for the first 2 years of this agreement a more expansive severance pay provision, and to that extent, you are absolutely right. It expands it for the first 2 years. If we terminate Mr. Zerlag within the first year of his employment, and these things are all things that no one sitting here at this table, nor Mr. Zerlag in his office, expect to happen, but if we were, under those circumstances, he would be entitled to 1 year's severance. If in the second year we terminated him, he would be entitled to 9 months, for sake of discussion, severance. And after that, the provision returns to what it has been historically under our contracts in the past, which is 6 months severance. This was, John requested the expansion of this language. It found some traction in my comments, discussions with individual members, and that's the reason it's here today.
Mayor?
Councilman Brumfield?
And I would say that I also talked with you. I didn't know that Mr. Zerlag had asked for that, but I had requested that that be put in, and the reasons for that, and it wouldn't have mattered who was the manager, is some level of consistency. This would be without cause, and not with cause, without cause, and that the first year that there would be somebody in place, and if there was the idea of asking him to resign without cause, that there would be a strong consideration that you really need to want this because it's going to be a price tag on it. And that's for the first year. And then, of course, the second and third year it declines. And the point of is trying to, once we go through this process, and all agree and hire a city manager, the majority hire a city manager, that there'll be a year and a 2-year. And if there is no cause, we've got somebody here. It's not something that's going to, in 6 months or 9 months or a year, change again on us. And so that was something that I had asked Mr. Lang to look at initially, right after when we began to contact him and put on calls.
Any other sections that council you wish to explore? Yes, Councilwoman Kerwin?
I guess
You want to talk about what this means for the future with
that's
other
exactly right.
contracts?
As a president, and the implications for the long term, not for right now, but what this in fact, because it's the position of the city that matters and our protection of.
And absolutely, and I would tell you this, that this contract is an individual employment agreement. It is tailored to one A period, John Zerlag. And Mr. Zerlag comes with experience and former city experience that most will not have, who, you know, in the future, that looking down into the future. And so the reason I say that is because each contract is an individual contract. And yes, certain provisions, just for ease and convenience, we just bring them forward. But there is certainly no reason whatsoever, given a different circumstance, that we cannot change that provision. And I would dare any potential applicant, no potential applicant is going to, I think, stand or fall on getting 12 months versus 6 months if we decide sometime in the future that, you know, this person, we're just going to do a 6-month severance. So I don't see it as an impediment to change in the future should the council believe that that is something we should do. I just don't see it. I mean, I would offer as evidence of that the mere fact that in the last contract, Mr. Nelson was paid more money than Mr. Zerlag. Yeah, we're making a reduction in his compensation, and we're not saying that's the starting point. We're reducing it. So I will tell you that if council's willing in the future and says, no, that's going to be a flat 6, we'll make it happen. Okay.
Any other areas you want to explore on the contract? Okay, if our discussion is complete, then there is a section in, we're going to have a resolution, not now, but in our regular meeting, item E4, in the meeting at 7:30 will be the resolution, not now, but we are going to take public comment at this time because that is our procedure with all of our meetings. So if there's anyone that wishes to speak, the mic, I believe this microphone is on. Good evening, Mr. Witt.
Evening.
Jack Witt.
Yeah, Jack Witt. I just want to say that $228,000 is too much, very simply. And while I appear here as a citizen, as a resident, as a taxpayer, you know, as Labor and Employment Counsel, I've negotiated scores of executive contracts for Fortune 500 companies. And it's always been important in those kinds of negotiations that it be an arm's length negotiation. Now, I have great respect for Mr. Lang. I know him a little bit. We've had some great discussions about labor matters. I'm not sure who's representing the city here. I assume all of you are. But I think it's extremely important that you understand that Mr. Zerlag has the right and the obligation to pursue his own interests with respect to the compensation and other features of this contract, and you have the obligation to represent the residents of this community. As far as whether $140,000 is a good deal, I mean, it's all relative, of course. In Macomb County, where I currently work, the new pay for the executive of the county is going to be set at $132,700. Now, Macomb County has over 800,000 residents, so it's substantially larger. Right here in Oakland County, the employees are taking a 5% pay cut over the next 2 years. All those senior individuals who have cars are told to turn them in. So it really comes down to it's compared to what. The big issue, though, is the pension. Putting aside the 140, and by the way, with respect to the 140, It's a false notion that this business about the health and welfare benefits, they're being paid. You're not going to double those benefits. So that's a false notion. But in any event, I think the problem's the pension. And I can tell you, having handled pension and other benefit matters for both large companies and large public entities with as many as 2,000 employees in the case of Genesee County, the fact is that many pension plans do require anybody who returns to regular full-time employment and is enjoying a periodic payment, a pension and annuity, that be suspended. In fact, that is the trend. I don't think the fact that somebody from GM comes back on a limited contract basis is comparable, for example. So that's a real problem. And it's a bit of a false notion that this benefit's already been funded, because the fact is, if it was suspended, funding in the future for this town and for its residents would be less if we applied that rule. Now, I've never looked at the plan document, and of course the plan document's controlling in these matters. But if the plan document's silent on it, I urge all of you to consider requiring that that pension benefit be suspended. So any notions that the pay's low, the benefits are low is false in the total context of what's going on here. The fact that, for example, he might be a retiree of another entity and come here and work and continue to receive the pension here is not comparable either, because it wouldn't be this city that's paying both costs. Moreover, the fact that he's a retiree here of this pension plan or system and now is working makes a sham of the notion of retirement. He is a retiree, or a retirant is probably the way the benefit plan puts it, and yet he's working full-time, regular, in fact, with a contract. That is, in my view, as a resident, inappropriate, and I urge all of you to consider that. Again, with respect to employment law and my HR background, I'm going to ask you, what do you say to employees who have to take a freeze in wages or even take cuts in pay in the future? What do you say to them? Oh, we have an executive here, chief executive is making $228,000. What do you say to an employee, say a clerk or a secretary, who has 30 years here and says, hey, I want the same deal. Let me retire return in a couple months after I take a vacation. I want to receive my current earned pension annuity, and I want my job back at the same rate of pay. And I'll pass on the retiree medical because, I'll pass on that. Of course, it's going to be paid since she's a retiree. What do you do with that person? Finally, what are you going to say to taxpayers? I would suggest that you not dare ask for an increase of your taxpayers after negotiating this kind of arrangement for an individual. So I ask all of you, represent the city properly, I urge you. And don't agree to an inappropriate and costly deal. And don't do the right thing because there's likely to be a response of outrage, but because you care about your role as an elected representative of the citizens. Thanks.
Thank you, Mr. Witt. Anyone else that wishes to make a public comment? Mary Ann Bernardi?
Thank you. I would first I want to correct a statement that was made. My husband works for GM, and under no circumstances is an employee allowed to return to full-time employment and continue collecting their pension. My husband and I have been discussing this pension, and believe me, I know that to be an absolute fact, and a statement was made here today that was, to me, a little bit misleading. Well, maybe even a lot misleading. Oakland County, I worked for Oakland County. Can I go back? I'm retiree, getting a pension. No, I cannot. I cannot go back full-time to Oakland County. Absolutely not. So I need to take a breath. This is kind of, this is perhaps a little upsetting to me that this council has put this city in such an unthinkable position. Now, as I understand it, he will not be accruing a new pension, but he will be drawing on his pension, which is $75,000. So we have $140,000 base, $75,000 coming out of the pension, which is able to also get. So, and then we have $5,000 car allowance. Then we have $7,500 deferred comp, for a total of $228,000. Okay. Now, I would just like to point out, in the Free Press Thursday business section, state jobless rate hits 15.2% in June. Actually, it's considered to be closer to 22.5% if the underemployed and those who have given up are included. Go further into that section, there's another article, same paper. Michigan's foreclosures are up from June of 2008, okay? Foreclosures, and they may go, in that article, they expect them to go even higher due to the high, extremely high unemployment rates in June, which also are expected to go higher. Property values have fallen and continue to fall. We are on a downward trajectory, which I think no one will object to that statement. State revenue sharing is down. Troy has a $4 million gap to fill. Our county executive, Brooks Patterson, has asked all county employees to take a 5% pay cut from the top down, including himself. While all of these forces are in play, you appear to be poised to approve a compensation plan of close to $250,000, but not quite. You've also allowed for flexible hours so that Mr. Zerleg can attend to another private business of his, which will bring in more income. And I have great, great concerns about conflict of interest issues, which are very minimally addressed in this contract as I was reading it. There's no direct enforcement, as you've just ascertained. And I don't think it's enforceable, unless you had someone walking around with Mr. Zerleg 24/7. Well, 40, not 24/7, but during the 40 hours a week that he's here. Well, actually 24/7, because it can be at home, and there still could be a conflict of interest in terms of which hat he should put on. Is he representing Troy's interests or his own? I have more to say about that later, so I'm not going to say anything right now more about that. Mr. Zerleg's two partners have left his consulting firm. Mr. Zerleg told me that he may use them as consultants to himself. Now, if this does happen, will Troy have to pay consulting fees to those people as well? Mr. Zerleg said that if Troy is involved, he will not collect a fee. But will his partners be paid, and or would the consultants that I just mentioned be paid? And I have three more questions. One, is there another city the size and complexity of Troy that does not have a full, I'm sorry, he is going to be a full-time manager, but who is being paid a compensation plan of $228,000? Is there another city that pays this much? And is there another city, county, or private industry that allows an employee to return to employment and continue to draw on their pension? I just heard that there are, but two of the examples I know not to be true. So I continue to lay the question before you. Thank you.
Is there anyone else that wishes to make a public comment at this time? Audrey Zembrowski.
Mine is mainly a question. If Mr. Zerleg is working here at the time and he has a consulting company, does he use the business phones from the city and use his office as part of the working business for him? Because I've seen this done at a church where I volunteered, and I was there every day, and a guy was working full-time for the church, and he also used his office and the telephone in real estate. And I think that was a conflict of interest. You're working for one, you should not be using the other. Just food for thought.
Is there anyone else that wishes to make a public comment? Mr. Obersinski?
Yeah. Jim Obersinski. I basically agree with what the previous speaker said. I also have some other concerns. I find it troublesome, the ambiguity in the contract. I know, Mr. Lang, you said, well, that's kind of typical for labor contracts, but I find that a little troubling. I also find it a little troubling some of the comments that made here. Well, we know Mr. Zerlag, so we know he would do this, wouldn't do that, and everything. I understand that concept, but when I was in the real world as an account manager and stuff, and I'd worked with my clients and stuff for years, and I get to know them real well. We're friends. We drink together and stuff. We'd go to some deal, and he'd say, "What? I want this in the contract, Jim." And I said, "Well, look, Chief, that's going to send a wrong message to management and stuff. I'll do that for you, but let's just not put it in the contract." And his response to me was, "Look, Jim, you're not always going to be my account manager, and I'm not always going to be here. And we're doing this deal between your company and my company, so yes, it does have to be in the contract." So I find that conversation a little troubling. The other problem I have with this kind of an agreement where you have somebody that's going to do some outside work, it's a lot easier if it's a production worker or something. Because, okay, you're on the line here 40 hours, that's your full-time job, and then you go do something else some other time. In this case, like, oh, it says full-time work. Okay, what is full-time work? That's not 40 hours, at least that's not my expectation. My expectation of a city manager here, particularly in the situation we are, is at least twice 40 hours. I think that person should be spending most of their waking hours working, strategizing, figuring out what we're doing in this city. Not spending 60 hours with us and then another 20 hours with the consulting thing. I think that it is just all wrong, the whole concept of having what I will still call part-time manager, regardless of what some of this stuff here says. This is just a nit, but vacation. 4 weeks a year, that's fine. But why would he get 3 weeks this year? What, he wants a week of vacation because he worked for 3 months under this prior deal? That's retroactive. That's bogus as far as I'm concerned. Like I say, it's a nit, but it's bogus. I hate to even be up here speaking because I get upset about things. Another thing, termination. I think we all know that rarely is somebody terminated for cause, unless they murder somebody or something, because then the person sues and everything. It's too big a deal. In reality, you want to get rid of somebody, you do it without cause and give them severance. Okay? So that's probably the only way we would ever terminate somebody. Then, so the first year, 100% base salary compensation. Now, if we were talking about hiring somebody from Timbuktu who was fully employed, like John Gaber, for instance, he's employed at Marine City, we're talking about that. Okay, he would take a risk taking this job. He would have to quit his job and everything. In this case, Mr. Zerlag he's not taking a risk. So why he would want to make it 100% in this first year, I think that is totally obnoxious. As far as the 50% in succeeding years, if that's standard, that's fine. I don't have a big problem with that. That's most of what I wanted to add. Thank you.
Thank you. Is there anyone else that wishes to speak?
I'll get a copy. Everybody else is angry, I haven't even read it.
Oh, well, it was online, and here is a hard copy, Pam, if you'd
Thank
like.
you. There were only 3 copies in the agenda list here.
Is that all right?
Sure.
Thank you.
Yes, I think there's somebody else here that also. Did you want to speak on it, or you just want a copy?
Thank you.
Okay. Anyone else? He didn't raise his hand. Oh, he wants a copy. I thought you were pointing at him. I thought you were pointing at him to speak. All right. Anyone else? All right. Then we'll be in adjournment and come back. Just a minute, Dave. We'll come back to you after. We'll take Councilman Eisenbarger's comment, and then we'll have our regular meeting at 7:30. Councilman Eisenbarger, you had another question or a comment?
Yes, I had been thinking about it from the standpoint of temporary employees being an employee in the auto industry, I'm used to having former people with a lot of skills come back for a period of time to work on special projects and whatnot. But the audience members that mentioned it, they always, when you have a former employee come back, it's always been on a part-time basis. This is a full-time basis. In your experience, what companies or governmental entities have you dealt with where a person is hired back full-time with their retirement benefit still in place to the same
My
entity?
experience is primarily in the public sector, so let me speak to some of those for you since we are in the public sector as well. Shelby Township. Plymouth Township. I think Coast Point.
Can you say what positions it was?
City manager, police chief. There's three that come immediately to mind. City of St. Clair Shores, fire chief became city manager, drawing pension. There's four. I could probably think of more, and I can do that, but there's four that come just to mind, just like that. There's four. I'd have to do more thinking off the top of my head to come up with more, but there's two city managers and two police chiefs that come immediately to mind.
Okay. Thank you.
Councilman Fleming?
I'm going to ask Mr. Lang here. You've got citizens that voice some concerns, and you listen. I don't know what the normal protocol is, but is this something anything you want to respond to clarify? Was there was some confusion or something for those that may be listening or watching on TV? Is something you might want to clarify of the points that were made? Maybe there was some misunderstanding.
Thank you, Mr. Mayor. I guess that it's an old cliche, but it is that beauty is in the eye of the beholder. And in essence, much of what Mr. Witt mentioned, he talked about comparability. I mean, I just would jump back. This is a new executive for Macomb County, and I represent counties and I represent municipalities. And in my opinion, with all due respect to counties, managing a city is much more complex than managing a county. They're starting their executive at $132,000 salary. The new executive for Macomb County. I don't know what Brooks but I suspect it's a lot more. Yeah. So in essence, that's why I provided you with comparables, both internal and external. In my experience in the public sector generally, we look to comparability in the external world, in the external and the public sector, and in the internal organization to ascertain what is reasonable. And I believe that under the circumstances, looking at the numbers that I've provided to you today, that in essence this is reasonable. And I do not believe that. And I guess I would, with all due respect, and I appreciate everyone's opinion, the pension is something that was earned in the past for service provided in the past. He does not receive a salary of $220,000 plus. That is not his salary. His salary is as per this agreement, and I suppose one can argue with this, with my interpretation, because everyone is entitled to an opinion. But that pension was earned based on his prior experience for this community, and he is entitled to that with or without regard to whether or not he is employed here. That is earned, and constitutionally he's entitled to it. Under the circumstances, and I think if there's willingness to waive any future accrual of pension, whether it's defined benefit or defined contribution, this contract fits well, and I think it is reasonable under all of the circumstances.
Any other council questions or comments? If not, then we'll stand in adjournment and we'll reconvene at 7:30 on our regular meeting.